So the Criminal Law Temporary Provisions Act was enacted on 21st of October 1955. It's a unique sunset clause which states that the law continues in force for a period of 5 years. Now this means that the law will lapse at the end of 5 years unless it is renewed by Parliament at today's second reading. The Act has been extended 14 times, the last being in 2018. The arguments for retaining this bill in our statutes have been put forth and debated on many occasions in this House. The essence of this law is that it allows the minister to detain a person who has been associated with activities of a criminal nature without having to charge that person or bring him to trial. If the minister is satisfied that the detention is in the interest of public safety, peace, and good order. The minister also has similar powers to order a person to be subject to a supervision of the police. And in this Act, activities of a criminal nature means any activity specified in the 4th schedule. In previous debates, the Minister for Home Affairs had listed the situations when the Criminal Law Temporary Provisions Act was applied. Firstly, against gang-related criminal activities. Second, against drug traffickers. Third, against unlicensed moneylenders. And fourth, against members of syndicates, example, global match-fixing syndicates. A more comprehensive list of the activities of a criminal nature are listed in the 4th schedule of the Act. So as a practicing lawyer, I am reluctant to deviate from this legal principle that every accused person is entitled to confront his accuser and to defend himself in a fair and public trial. It is an important principle as it prevents the abuse of process by an incompetent or corrupt government. However, I accept the argument that this law is needed in unique circumstances where witnesses are unwilling to testify because of the fear of harm to themselves or to their loved ones. Indeed, when this bill was up for renewal in 2009, I had supported the renewal of the bill. At that session, I given an account of a criminal case that I did in 1990, when I was asked to interview a secret society member who was charged in court for murder. However, 15 years later, the question before members of this House is whether the current state of criminal activities in Singapore would still warrant renewal of the Act after almost 70 years since the Act was first introduced. Is this law still relevant to Singapore in this day and age? Is it still necessary in maintaining law and order? For most members of this House, we have limited knowledge of the state of criminal activities, save for what was reported in the media or by the police. For example, in February 2021, Home Affairs Minister Mr. Shanmugam, in reply to a PQ, said that the secret society situation in Singapore is under control. Minister further said that an average of 112 rioting and serious hurt cases have been linked to secret societies in Singapore each year for the past 5 years. And cases involving the use of weapons such as parangs and knuckle dusters have declined over the same period. He said there was one case involving weapons last year, down from 12 in 2016. On 5th of July 2021, Minister said in a reply to another PQ that notwithstanding that the secret society situation remains under control, the participation of youths in secret societies remain a concern. That's why we invest significant resources to educate and engage youths to deter them from joining secret societies. For illegal loan shark activities, in an October 2020 reply to a PQ, Minister Shanmugam said that between April and August 2020, there were 1,587 cases of unlicensed moneylending and unlicensed moneylending related harassment reported. And this was a 40% decrease from 2,642 cases reported during the same period in 2019. Next, for drug-related offences. In the 2022 COS, Committee of Supply debate, Minister informed this House that in the 1990s, CMB arrested about 6,000 abusers per year. Now, it arrests about 3,000 to 3,500 per year. Further, the death penalty is a key part of our system and approach to deal with drug traffickers. Thus, the question is, if the secret society situation in Singapore is under control, if the cases involving unlicensed money lending has come down by 40%, if the number of drug abusers have also come down drastically since the 1990s, is there still justification for this law to be extended? So I listened carefully to the cases of secret society attacks by Minister of State, Mr. Faisal. However, in every criminal case, there will always be a risk of retribution, whether by secret society members or by simple criminals. The question is, how can we balance the interests of an individual to the right of due process versus the right of members of public to a peaceful and safe living environment in Singapore? So I've always been proud of the fact that Singapore is ranked one of the safest places in Asia to visit. According to the Global Peace Index, the safest Asian country to visit is Singapore, followed by Japan and Malaysia. It was reported that these countries have low levels of violence, crime, and conflict, and high levels of stability and security. The country that tops the list of safest country in the world, not just in Asia. So the country that tops the list of safest countries in the world in 2024 is Iceland, followed by Denmark, Austria, and New Zealand. So my question to the Minister of State is whether these countries also have similar legislation that allows them to detain criminals without trial. How did they maintain their record of being safe countries to visit? And how did they deal with criminal activities that Singapore is so concerned with? So I submit that it's incumbent on the government to explain to Parliament that the rationale for keeping this law so that it is incumbent on the government to explain to Parliament what is the rationale for keeping this law so that MPs can make a considered decision whether to extend the same for another 5 years. And that's the purpose of the sunset clause. If the Minister is able to make out a compelling case, then I'll be happy to support the extension. To me, and I reiterate, that this is all about striking the right balance between having the right to due process versus the need to maintain law and order in Singapore. So allow me to also state for the record that I'm quite satisfied that there are sufficient safeguards to ensure that there's no abuse of power by the police. I perused the Hansard in respect of the 2018 debate on the extension of this law, and having read about the 6 safeguards listed by the Minister for Home Affairs, I'm sufficiently convinced that we do have a robust process to ensure that any decision made by the Minister to detain a person without trial is carefully scrutinized and assessed. In particular, I'm of the view that having the consent of the public prosecutor before the making of a detention order is an important requirement. The public prosecutor, who is also the Attorney General, enjoys security of tenure under the Constitution, and the public prosecutor is free to disagree with the police or even the Minister and still enjoy security of tenure. Next safeguard is having sitting judges of the Supreme Court of Singapore chair the advisory committee. And that's another key factor that persuaded me that any person detained under this law would have sufficient safeguards to ensure that there is a strong basis for the detention order. We are having the best judicial minds reviewing the Minister's basis for the detention or supervision order and challenging the decision of the police in requesting for such detention or supervision order. And these orders will be reviewed annually by different advisory committees which will be chaired by different Supreme Court judges. And the final safeguard that I'm satisfied with is the fact that Parliament has to review the necessity of this law every 5 years due to the expiry date or the sunset clause of this law. So, sir, I await to hear the justifications to be given by the Minister for Home Affairs for the extension of this law for the 15th occasion.